President, please be seated. The court is back in session, and the chamber now hands over the floor to the defense counsel for Mr. Nuon Chea to resume your observation and reply. You may proceed.
Thank you, Mr. President. I've been urgently requested to slow down, so I will. Next, Mr. President, are documents E3/2281 and E3/2262, both of which are described as lists of Khmer Krom. Now we understand that both of these documents are two of only three so-called Tram Kok district records for which there is in fact an original held at the Tuol Sleng Museum. Accordingly, given our concerns about the provenance and chain of custody of the Tram Kok district records as a whole, we request that the Chamber obtain permission for these originals to be added to our case file. Additionally, we note that these lists are simply lists. They are not prisoner lists or execution lists, but simply lists. One apparently from Trapeang Tom Chung and the other from Popel. What therefore does the prosecution want to suggest exactly as to their relevance? Without any further concrete evidence as to what happened to the people on this list, the reference to these lists alone is inconsequential and with zero probative value. Also, in this section on the treatment of the Vietnamese and the Khmer Krom, the prosecution made their first reference to document E3/2048, a document which they highlight repeatedly at various points in their document presentation. In this first reference, the prosecution highlighted a page which it described as a May 1977 list from Popel of 64 Khmer Krom families evacuated from Vietnam. Here, Mr. President, our first objection is again about form. This document, E3/2048, is not only a photocopy for which there is no located original, but it appears to be a photocopy of a photocopy. And in addition, the document appears to be a compilation of various correspondence, yet someone has gathered it together and presented it as a single document. And again, the questions of who, when, why, and how become critically important. And these concerns, together with the prosecution's heavy reliance on this document, magnify our concerns about provenance and chain of custody, and make it even more necessary for the Chamber to search for the document's originals. Moreover, and just as with the previous two lists referred to, without any clear evidence about what happened next to the people featured on the list itself can only be of very limited relevance. Mr. President, the prosecution round out its section on the treatment of the Vietnamese and the Khmer Krom by referring to Henri Locard's report called Tram Kok District in the Grip of the Khmer Rouge. That is D313/1.2.16. In addition to the general objections I have already mentioned in connection with this report, we also object that Locard's report itself is irrelevant. He is simply doing what we are doing, analyzing the so-called Tram Kok district records. Moreover, we challenge whether Henri Locard has expertise that may truly add value to such an analysis. The prosecution characterizes Locard as a quote-unquote historian, political science, quote-unquote, and quote-unquote leading expert on Cambodia and the Khmer Rouge. And they do that in their witness summary, which is document number E305/6.4 at ERNs 009866615 in English, 00997433 in French, and the Khmer ERN is not available. However, our understanding is that Locard has degrees specializing in the English language, and it is therefore unclear what particular expert insight that he could bring. If it is simply about him spending a long time in Cambodia and being curious about Khmer Rouge issues, then I suppose any number of ordinary Khmers might also fit the bill. Prosecution further admits in its witness summary that Locard was previously employed by them. And we have previously said, in the light of his employment with the prosecution, that Craig Atchison's testimony should be taken with a grain of salt, as I believe your chamber has said as well. And we would therefore say that Henri Locard's testimony or his book or his works, given his employment history and irrelevant qualifications, should be taken with a bag of salt. Mr. President, Your Honours, I move now on to the next topic, the treatment of Lon Nol soldiers and officials. The prosecution's third thematic focus is on the treatment of Lon Nol soldiers and officials within Tram Kok district and at Krang Tachan. Before we go to...
President, hold on. There was no translation a while ago. President, you may resume your reply, the last points that you made.
Then I will start with talking about the prosecution's third thematic focus, which is on the treatment of Lon Nol soldiers and officials within Tram Kok district and at Krang Tachan. Before we go to our objections on specific documents, we would like to raise the general objection that even if Lon Nol soldiers and officials had been targeted, and we do not concede that, this of course must be considered in a historical and geopolitical context. Targeting itself, if it happened, would not of course be strange in light of the fierce civil war with Lon Nol, which immediately preceded the decay. As a matter of fact, any country might have done the same at that point in time. Now going to E3/2120, which is Meng Tri Yi's book called The Chain of Terror, and which is the first document relied on in this theme by the prosecution, to which we wish to object. Supplementing the general objection we have already made regarding the need for Meng Tri Yi to testify about his methodology, we note that he published this study under the auspices of DC Cam's Searching for the Truth publication. We also note that on the case file is what happens to be an earlier draft of Meng Tri Yi's book, which contains comments and suggestions from Yuk Chang, who is of course the DC Cam director. Comments from a person identified as Steve, who is presumably Steve Hedder, and a third unidentified author. And Mr. President, Your Honors, I would like to draw your attention to one of those comments. In one passage, Meng Tri-E relays how an interviewee could describe prisoners in sub-district militia centers plowing fields alongside non-prisoners. And this interviewee could concluded that, and I quote, "Even the people without the blame worked very hard, so prisoners must have been forced to work even harder," unquote. Following immediately on from this, an annotation from Yuk Chang, which reads, and I quote, "You know I hate this paragraph. It makes the survivors sound too weak. People have to work hard. Here I think we refer to people's rights and freedoms being taken away. Or maybe just delete this paragraph," unquote. This appears, Mr. President, on an older version of the same document, E3/2120 on the case file at English ERN 00105683 in English, nowhere else. Although Meng Tri-E retained the passage in the final version, this example of a comment from DC Cam's director shows that its widely accepted status as a neutral organization may in fact be questionable, and it may better be considered as an advocacy group. In addition, and as with Henri Locard, to the extent that Meng Tri-E's conclusions in the book are drawn simply from an analysis of the Tram Kok district records, then we would object that they are irrelevant unless the prosecution can satisfy the chamber of his particular expertise. Of course, to the extent that the book is based on interviews that Meng Tri-E conducted, then its content may be relevant. However, even in this case, it would be necessary for him to come and testify about his research methodology. The next document, Mr. President, to which we refer in this section on the so-called targeting of Lon Nol soldiers and officials is E3/4095, and it's the Krang Tachan Interrogator's Notebook, as it is called. This is a document we also refer to at length in our own document presentation. However, we wish to make the following objections with respect to the prosecution's use of this document. First, we note that the cover page of this document does indeed bear the title Fifth Confession, Contemptible Traitors, Pol Pot and Ieng Sary, a title clearly added after the DK period and signaling without any doubt that this document has been tampered with. In addition, we note that the prosecution's summary of the document's relevance pointed to, among other things, the reason for certain prisoners' arrests. Now here again, we feel that the double standard returns. Given that this document is apparently the result of a prisoner's interrogation and confession, it would seem again that the prosecution is seeking to rely on the contents of a confession. The inclusion of this document in the prosecution section on the supposed targeting of Lon Nol soldiers and officials prompts us to make a number of additional points in relation to this document. First, when reviewing the contents of the confessions within this document, it seems that no one in the document is being interrogated simply to determine their rank within the Lon Nol army or administration. Prisoners were interrogated because they were perceived to have done something. This is illustrated by even the very first example in the notebook. This entry relates to a man named Yuan Heng, a non-commissioned soldier who allegedly, and I quote, had a grudge against a comrade in trade affairs and attempted to axe him to death. End of quote. English ERN 00747-237, Khmer 002711090, and French 00721206. We can compare this with other examples with which the Chamber is already familiar, including people mentioned in the same notebook who were not Lon Nol soldiers and officials. An example that we have discussed at some length in this regard is the family of Mia Soka. They too were not arrested arbitrarily, but had in fact been accused of plotting to overthrow their commune chief. And I might add that the husband of Rad was also accused of having raped a new person. Second, Mr. President, the notebook is clearly a very brief summary of the interrogations. Alone, therefore, it should be considered inadequate evidence of the reasons for a person's arrest. What we need to see, for example, is documents from the sending locations and documents indicating what happened to the people next, such as a possible execution or a release list. Our objection in this respect applies also to other documents which the prosecution used in this section of its document presentation, namely the documents E3/2107, E3/2048, and E3/2432. Allow me to add a few additional comments in relation to one of those three documents, which is E3/2048. The specific document within the compilation to which the prosecution referred at this point in its presentation was the April 1977 report from Tapem Commune, Chief Kit to Ankar, ERN English 00276564, Khmer 00079791, and French 00611. As the prosecution highlighted, this document seems to suggest that Lon Nol soldiers were being identified on that basis of their identity as such at that time. Now, of course, our general objection still applies here, that there needs to be additional evidence corroborating the fate of the people identified in documents such as this. However, this document and its date are also significant, we believe. And that is because it seems that from approximately mid-1977 onwards, there appears to be a shift, at least in the so-called Tramkok district records, with people being identified on the basis of their former Lon Nol military or administrative rank. As far as we can see, these types of documents do not seem to exist before that time. Therefore, it might suggest that there are, in fact, two distinct periods, before and after mid-1977, which seems to be in line with Pek Chim's testimony last Friday and the Southwest Zone cadre's statement about the meeting shortly after the liberation in Takeo provincial town, during which Tamok said that, and I quote, "soldiers with the rank from second lieutenant to colonel were not to be harmed," unquote. Mr. President, Your Honours, to be clear, this is not a concession that Lon Nol soldiers and officials were targeted. Obviously, and as we have already said, further investigation into the provenance and chain of custody of the so-called Tramkok district records needs to be carried out before they can be relied upon as key evidence and any conclusions drawn. On another topic in relation to the same document, E3/2048, I note that later in its presentation, the prosecution highlighted one passage in another document within the compilation, and that is a 2 May 1977 report from Pan of Popel Commune, English ERN 00376563 until 4, Khmer 000799090, and French 006116661. In the relevant passage, point 2 of the report, Pan reported that, and I quote, the 106 military families smashed by Ankar, including those who died, totaled 393 persons, unquote. Now, on this subject, I would like to refer again to the testimony of witness Baek Chim during last week's hearings. As you may recall, Baek Chim explained that smashed has two meanings. It may refer to eliminating a person in the sense of eliminating their erroneous mindset, and it may also mean eliminate in the sense of kill. Now, we believe that the Chamber's position on the meaning of smash, as established in case 001, is overwhelmingly focused on the testimony of Duik. However, assuming it could be true that smash could have had a variable meaning during the decay, we would argue that Baek Chim's testimony as to the meaning of the word smash is much more relevant in this situation than Duik's testimony. Why? Baek Chim was, after all, a Tramkok district secretary during the decay, and the documentation appears to show that instructions as to people's fate were often sought from the district level. In addition, we know that the trial chamber considers him, Baek Chim, to be a credible witness. According to our count, you relied on Baek Chim's testimony a considerable 16 times in the case 002/01 judgment. So, taking Baek Chim's definition of the word smashed or smash into account, then, the fact is that it is possible that the reference to the smashing of the military families in E3/2048 might not in fact mean their execution. Perhaps it might mean their transfer to a re-education center or another administrative framework, for example, or somewhere else. In any case, it requires further investigation before conclusions can reasonably be drawn. Mr. President, I will now make very brief objections regarding documents in the next 5 themes on which the prosecution focused in its document presentation. First, regarding the treatment and targeting of new people in Tramkok district, our general objection here is that the prosecution did not show any documents proving that there was a policy to treat new people any differently from anyone else. And although I'm not allowed to react on what the prosecution said this morning, we heard him quote from standing committee meetings, and the crucial word in his quote is, of course, the word among. It is being argued that there are bad elements among the new people. The new people as such are not bad. That is, of course, also an important point of appeal. The next theme, Mr. President, is about people who were arrested for opposing or criticizing the revolution, the party, or Ankar. Regarding the supposed arrest of people who opposed the party, we note that the prosecution principally relies on interrogators' notebooks here. In particular, E3/4095, E3/2107, and D157.7, which is now E3/5827. Once again, we refer you therefore to our objection in relation to the summary form of those notebooks and the fact that it is essential for us to have additional documentation to corroborate interrogators' notebooks and confirm the fate of the people mentioned within these notebooks. Otherwise, the evidentiary value of the information in the notebooks alone is limited. Next, Mr. President, it's about the people who were arrested in connection with food or working conditions. I leave aside the rhetoric, the closing submission style rhetoric of this morning from the prosecution. And what I do like to say is that regarding people supposedly arrested for stealing food or complaining about food or working conditions, we note that this is something that has been clearly contradicted, and I might add convincingly, by all cadres who have so far testified. We also pointed to other evidence during our document presentation on Tuesday that suggested, on the contrary, that people might be re-educated multiple times, including for much more serious offenses than just stealing a coconut. In addition, and again, it is necessary to see additional documentation that might complete the picture, as the interrogation notebooks forming the basis of this evidence again offer only very summarized information. It is also possible and probably quite likely that information that a person might offer up in an interrogation might be totally different from the reason for which they were actually arrested. Then the next theme, Mr. President, people who were arrested for trying to escape or moving around too freely. In respect of this theme, we contend that the evidence also must, of course, be seen in context. If we take into account the security situation, and especially the severe internal factions and fomenting internal rebellion, which without any doubt existed within democratic Cambodia, it is completely reasonable to see why a person might be detained at first if they were found to be somewhere where they didn't have permission to be. Whatever that may be, in any case, once again, the documents that the prosecution cited do not indicate what happened to the people after their arrest. Then, concerning the arrest of children and the elderly, we wish for now to comment on only one of the documents that the prosecution raised, the document which he referred to as D157.36, and to which the Chamber has now assigned the new E3 number 8417. This document concerned 23 and 24 March 1977 reports from Angro Ka and Ankar, including, as the prosecution highlighted, the arrest and confession of a 10-year-old boy as part of a group which had tried to flee. Our objection is here that the prosecution quoted selectively from this document, because when you look at the document in full, there are key details missing from the prosecutor's account, which give the event a different color. Because the boy was captured in a group of people who, and I quote, had 2 pistols, unquote, and many 79 type bullets, unquote, which doesn't exactly give the same rosy picture of childhood innocence as the prosecution would like us to believe. The DRN numbers that I'm referring to, Mr. President, are English 003636449 until 50, Khmer 0027090089, and French 00607873. Now I turn to the authorities' procedures for arrests and executions. In this theme, the prosecution also briefly presented two documents in respect of the theme concerning these procedures for arrest and execution. The first was Henri Locar's report again, and from this document, D313/1.2.16, the prosecution quoted a passage which indicated that there was no documentation of quote-unquote revenge killings of the new people, and that quote, killings by DK were centrally planned, and that as in similar regimes, the Nazi or the Stalinist varieties, bureaucrats and executioners had completely surrendered their free will to the party, unquote. Our objection here is actually that we completely fail to see how this is relevant and probative at all. It is simply an unsubstantiated shopping list of very tired cliches. As for the second document, the film Deacon of Death, E3/2316R, we have a number of concerns as to the documents or the film's probative value that we intend to investigate it before coming back to it and commenting in our closing submissions. In particular, we can see the setting is not a legal setting, but appears to be a form of testimonial therapy. And to this end, we need to investigate the methodology undertaken in order to be able to rely on the information divulged in this film. And secondly, we also need to verify various details, including the identities of the people featured, the location, and whether the English subtitles are in fact accurate. And this could take some time, given the fact that the documentary is 1 hour and 4 minutes long. Then the use of hot methods in interrogation. That was the prosecution's third last theme. As we have presented contrary evidence on this topic in our own document presentation, we will not say now anything further about this matter at this point. The prosecution's second last theme in its document presentation was the use of Krang Tachan documents in further interrogation of others. And here the prosecution presented a single document, E3/2012, which allegedly was an 11 July 1977 report from Prison Chief An on the confession of a prisoner named Sin Yung. Now, as the prosecution highlighted, this document contained two handwritten, unsigned annotations. The first regarding Sin Yung and reading, quote-unquote, to be smashed. And the second regarding two people who Sin Yung identified and which read, quote-unquote, to be arrested. As this document only exists as a photocopy, however, it is impossible to verify whether these annotations were written in red ink, which witness Beck Jim explained last week was apparently a distinctive feature of such annotations. It's also unclear whose handwriting it is and when it was annotated to the document. And finally, Mr. President, this document is one of several in, again, an apparent compilation, and therefore our same objection and concerns as to the provenance and chain of custody apply. The last point in the prosecution's document presentation is the reporting to the district and from the zone to Phnom Penh. We have a few objections about the three documents that the prosecution highlighted in this section. First, let me turn to the first two documents, that is documents E3/2109 and E3/4085, which the prosecution described as monthly reports from Krang Tachan. Our objection is that neither document actually stipulates that they are reporting about Krang Tachan. The name Krang Tachan, or rather Re-Education Center 105, is never mentioned in this document. Also, more specifically, the first document, E3/2109, includes other information on, for example, the issuance of rice to Samrong district and of manioc to Toteung Tignai. These details make it arguably unlikely that the document is a Krang Tachan document. It may be a district document, but this has not, in our view, been established. The last document is a very interesting document which featured in the prosecution's presentation was the document numbered E3/853, which was a report of the Southwest Zone to Ankar, presumably the center, dated the 3rd of June 1977. Our objection in this regard, Mr. President, is that the prosecution appears to have presented the information selectively and omitted key details. And these key details include the following. First, the report was entitled Report Number 10, which would imply that there are reports 1 to 9. If there are any, where are they? Secondly, but more important, while the report appears to describe a very serious defense situation within the zone, with many enemy activities taking place, the defense section of that report is only about 1/4 of its total length. And it doesn't seem to reflect paranoia. If anything, it seems to be modest considering the events it describes, including the Chan Rengzi force attack, the firing of enemy shells into DK territory, the movement of Vietnamese troops into the country, the digging of trenches, and most vividly, and I quote, the enemy launching their activities by burning children alive, unquote. And you can find that on English ERN 00185 243 and Khmer 005 2825 and French 002 90267. Finally, in the document, the Southwest Zone reported to the center that it would take the following quote-unquote measures for the future. All levels must be put on full alert, and all enemy tricks and activities must be kept under 24-hour surveillance, but very quietly. Now, these steps, which also appear to be the only directive sent from the zone down to its lower levels, are, besides being very proportionate and reasonable, far too generic to enable conclusions to be made about treatment of people in individual cases. Mr. President, Your Honours, that concludes our comments concerning the prosecution's document presentation on the Tram Kok cooperatives and Krang Tachan. Next, regarding the civil party lead co-lawyers presentation. At this stage, also given the limited time available, our objections will only be very brief. But of course, I note that we plan to provide detailed comments in our closing submissions and on other occasions as appropriate. In short, we object to the lead co-lawyer's technique of extensively quoting from applications of civil parties who are not going to appear in this courtroom. This is especially so where their testimony may go to the acts and conduct of the accused. Now, as we briefly said on Monday, our view is that document hearings are intended to give the parties, us, an opportunity to highlight for the Chamber and the public key documentary evidence, documentary evidence, on the case file that may not otherwise be explored in court. We believe, therefore, that the intention is for us to focus on documents other than statements of witnesses and civil parties who are in principle capable of testifying here in this courtroom. It follows that these hearings should generally focus on contemporaneous documents that can establish facts and corroborate or contradict witness testimony and memories. And on Monday, the lead co-lawyer said that she would speak on behalf of civil parties who had not yet testified in court. In fact, however, the 6 civil parties who were featured on Monday will never testify in court, because the lead co-lawyers did not request their appearance, and neither did any other party. And in this context, highlighting those civil party applications by reading them into the record word for word amounts to, we believe, allowing those civil parties to sort of quasi-testify, yet preventing our client, Nuncia, the other parties and the Chamber from asking follow-up questions, testing that evidence. Obviously, we believe that such a practice cannot have any place in this court. Finally, and I will conclude, Mr. President, Your Honours, and on a more general note, it is clear that it is necessary for us to have some more clarity from the Chamber on the procedure for document hearings. Our client Nuncia was, for instance, was very angry at the Chamber's treatment of the Q Sampan team on Tuesday, and we were surprised also, given that the evidence that they were presenting seemed, in our view, to be perfectly reasonable. So we do hope that to have some more clarity on this before the next document hearing is being held. Thank you very much.
President, thank you. And the Chamber would like now to give the floor to the defense team for Q Sampon. Kong Samon, thank you, Mr. President. And first of all, good morning, Mr. President, Your Honours, and all parties. I noticed that we have about 20 minutes left before our lunch break. And if I cannot finish it before the lunch break, could you grant us just a little bit of more time so that we can conclude our response and the proceeding for the morning session? I observed all the key document presentations by both the prosecution and the lead co-lawyers for civil parties. My colleague told me that there is no translation into French. Allow me to repeat that. If we can finish it before the lunch break, that would be great. If not, please just allow me a little bit of more time so that we can conclude everything for the morning session. In relation to document E3/1593, which is an extract from Ben Kiernan, I also heard that Councillor Copper already responded to the presentation that so far Ben Kiernan has not appeared before the Chamber, and we have not heard any intention of summoning him to testify before this Chamber. For that reason, the probative value of the document by this particular individual is in question. And I believe your Chamber already issued an instruction in relation to the proceedings in case 002/01 in terms of the probative value of the work of Ben Kiernan. Regardless of that, I noticed some irregularities in the work of Mr. Ben Cannon, as there are contrasting facts regarding the different food rations in his work. In the presentation by the prosecution in relation to document E3/1593 with the Khmer EAN, that is 00678585, it shows that witnesses claims that the food ration in Tramco district was not a critical issue, and this is contradicting to what was presented by the prosecution, as the only initial part of that related text was mentioned by the prosecution. Another document, that is E3/760, which is the extracts of the Revolutionary magazine. My apology, the document is E3/139, which is the 11th edition of the Revolutionary Flag magazine of November 76, with the Khmer ERN 0064965-66, and in English is 00455284, and in French 00491919. And allow me to provide you an extract of that free translation. What was the food ration? We actually solved the key issues in 1976, and we continue the practice of the 13 tang of food ration further into 1977. The party decided that the 13 tang food ration had to be completed or had to be implemented fully, and it should not be reused to the 12 tang food ration. Also, in the special edition of the Revolutionary Flag magazine of December 75 and January 76, which is E3/25, ERN in Khmer is 00063054, and in English 00491436, and in French 00. President, the International Deputy Co-Prosecutor, you have the floor.
I just want to note for the record that neither of the last two documents that are being discussed are documents we presented. These are documents that were on the list of documents Q-Sam Pan's team wished to present. I actually have no objection to him using this opportunity, but I just want the record to be very clear. They are not responding to documents we presented. They are reading from the documents that they had planned to read back on Tuesday.
Council on Mr. President, I'd like to respond to that observation. Within the framework of the responsibility of my client, that is Mr. Kieu Sampon, which is different from the other accused in this court. And as Mr. Kieu Sampon expressed his opinion on his stance to support the policies of the CPK during the DK period, we are therefore of the view that if we do not raise the issues or the concern of the policies of the CPK, in order to show that Kieu Sampon, my client, has nothing to do with the practice at on the ground. And also, so far, the prosecution fails to provide any linkage between Kieu Sampon to the practice on the ground. And for that reason, allow me to show the policies of the CPK. President, yes, you may proceed with that presentation. And of course, the Chamber noted your observation, Mr. Deputy Co-Prosecutor. Council, thank you. And allow me to read an extract of that special edition of the Revolutionary Flag magazine, December 75, January 76, as follows. The importance of the communism and the socialist construction is to build a better country and to resolve the living condition of the people quickly. End of quote. Secondly, in regard to the cooperatives, the prosecution presented documents on the three categories of the population. Namely, the base people, the candidate, or the reserved, and the depositees. We did not see that it was the intention of the CPK policies on the categorization of the people in terms of a workload or a food ration. In document E3/742, shows the different types of workforces as presented by the prosecution for the purpose of a good collaboration in achieving the work outcome. And on the issue of the decision-making process to reclaim Cambodia Crown, and and the prosecution made a presentation on that issue by showing the armed conflict that existed during the decade period, in particular in the Tramco area. We are of the view that the presentation made by the prosecution, by reliance on the statement of Tassan, who was one of the district secretaries and who attended the meetings with the commune committee in order to explain to them the purpose of the organization to reclaim Cambodia Crown. That presentation is out of the current scope of the proceedings. In fact, the chamber issues a decision, document E315, on 12 September 2014. And on this very issue, that is on the issue of armed conflict, which was in the subparagraph F. And for that reason, we prefer not to respond to the presentation by the prosecution in relation to the attack and the reclaiming of Cambodia Crown territory. For the same reason, in terms of the treatment of the Vietnamese and the Khmer Crown, the prosecution presented several documents. For the current proceedings, this topic is not part of the facts to be debated. That is, we do not debate about any particular target group. Therefore, we prefer not to respond to that presentation as well. And on the issue of the purchase of the former Lunal officers and officials, the prosecution presented a document that is E3/2120, which was authored by Ear Maintry. We reviewed all the points referred to by the prosecutions, and there were 6 of them. 2 of the main points were on a general situation, while the other 4 were on the specific events. However, none of the 6 points has any relationship with the Tramco district. And there is a very remote possibility that one point was related to nearby districts, that is Prey Kaba district and Bati district, where 2 individuals, Chen and Tuit, provided such information to Ear Maintry, the author. For that reason, the presentation made by the prosecution in their attempts to link the text to Tramco district is wrong, as it was related to other 2 districts, that is Prey Kaba and Bati. And finally, Mr. President, another topic that I to respond. The prosecution made a presentation regarding the other offenses, namely stealing food, stealing coconut, or in terms of gathering ducks to go into the rice field. And on this issue, I concur with the presentation or the response made by Council Copper. In the testimony of Dachin, who was a former district secretary, and also in the testimonies of other former cadres, who states that for such minor offenses, those offenders were not sent to Kantachan, a security center, rather they were educated on the ground or reprimanded on the ground and not to repeat the same offense. So this is for your honor consideration. And now I'd like to briefly make my response through the presentation by the lead co-lawyers for civil parties. The lead co-lawyers presented 5 victim information forms, namely E3/6143, 6457, 4988, 6222, and E3/5069. They also referred to a written record of interview before OCIJ. That is document E3/5519. And before I am on my feet, Council Copper also responded through those documents. These individuals so far have not appeared before Your Honor's chamber, and there is no foreseeable plan that they will be called. So in such a criminal case of their attitude, their statements or information cannot be used as a probative value or evidence in this court or in this proceeding. And Council Giro also said that she acted as the spokesperson for the civil parties before Your Honor's chamber. And that is her statement on the 27th April 2015, around 14 hours, 22 minutes and 23 minutes and 23 seconds. I believe Your Honors will not have a problem at all in considering this issue, that the lawyers for the civil parties are not the spokespersons for their clients, in particular in such a criminal case. They can, however, become the spokespersons of the civil parties in terms of their claims for reparation. The civil party lawyers themselves also acknowledge that there are many discrepancies in the testimonies of the civil parties compared to their victims' information forms. And that is in reference to the transcript document E1/288.1 at 09 hour 40 minutes and 49 seconds. 59 seconds rather. Based on all the points that I presented to you, Your Honors, the presentation made by the lead co-lawyers for the civil parties by solely reliance on the victim information forms of their clients who are not summoned to be called to testify before this court does not lend itself to ascertain the truth. For that reason, that information is not of a probative value. And that is the end of my response, Mr. President. Thank you. President, the hearing to hear the responses to the key document presentations by the parties in relation to Tramcock Cooperative and Counterchan Security Center has come to a conclusion which is earlier than what we scheduled. We therefore adjourned the proceeding now and resumed on Monday, the 4th of May 2015, commencing from 9 o'clock. On Monday next week, the Chamber will hear the testimony of a witness to TCW 979 by a video conference. And security personnel are instructed to take Nunchi and Kyu Sampon back to the detention facility and have them return to participate in the proceedings on Monday, 4th May 2015 before 9 o'clock. The court is now adjourned.